So our next topic is digital assets and cryptocurrency, regulation and enforcement of exchanges, crypto lending, DeFi, NFTs, and stable coins. And I really don't think there could be a better day to have this panel, maybe yesterday, but not too many other days would be better, because there is just a lot going on. So let's start off by introducing our panel real quick. Let me introduce Michael Birnbaum. He is a partner at Morrison and Foerster in New York, where he regularly counsels global financial institutions and issuers through investigations and potential litigation. He is a former senior trial counsel at the SEC, where he served for 11 years. Welcome, Michael. David Hirsch, we are very pleased to welcome. He is the new chief of the Crypto Asset and Cyber Unit in the SEC's Division of Enforcement. Prior to that, he served as counsel to SEC Commissioner Crenshaw, primarily responsible for matters related to enforcement, along with digital assets and cyber. Welcome, David. Simona Mola, a principal at Cornerstone Research based in DC. She conducts financial and economic analyses, and she has particular expertise with economic issues involving cryptocurrency, ICOs, blockchain use cases, and token economies. And she was previously herself an assistant director and senior policy advisor at the SEC. Welcome. James Walker is with us. He is a partner at Perkins Coie based in New York. James represents professionals in securities, regulatory matters, and internal investigation, and currently focuses much of his practice on digital asset companies, representing them in these types of matters. Welcome, James. Finally, very pleased to welcome our moderator, Luke Cadigan. He's a partner at Cooley. He's based in Boston and head of business litigation for the East Coast. Luke's practice is concentrated on securities enforcement matters, shareholder disputes, complex commercial litigation, and he's a former assistant director in the SEC's Enforcement Division, where he served in both the Boston Regional Office and in the SEC's FCPA unit. Luke?
Thanks very much, Bruce. What a year in this space. I mean, this panel is crypto lending, DeFi, NFTs, and stablecoins, and frankly, it could be several other categories. And where do you start? I mean, as you look back on the year, it started with such optimism. If you think about it, relative optimism at least, you had so much money pouring in from venture capital, more than at any other point. Thereafter in March, you had the Biden executive order, a comprehensive framework for the development of digital assets. And then you start seeing commercials on TV daring you to invest in crypto from the likes of Tom Brady and Matt Damon. However, as you know, that was followed by the collapse of the Terra Luna stablecoin, the massive drop in Bitcoin, and even last week, the collapse of FTX. And despite calls for regulation in this space, there were none. You saw turf battles with the SEC and the CFTC. And the SEC made very public its stance that no new regulation was necessary. The ones on the books covered all of this. And what you also saw was the SEC staff doubling the enforcement staff dedicated to crypto cases. And you saw one case after another in an ever-expanding scope of market participants that were being brought with ever-expanding theories here. And so with this, the question that came to all of us as we got started looking at this panel is where to focus with so much going on and so much that's occurred. And so with that, we're thrilled to have you, David, here to tell us, in your role, obviously relatively new role as chief of the Crypto and Assets and Cyber Unit, what can you tell us about what we can all expect going forward from your unit?
Thank you very much. Thanks everyone for having me here today. Before I get started, I need to provide the obligatory disclosure that the comments I'm going to make today are my own and not those of the commission, the commissioners, or my fellow staff. So given that, I think that we can expect to see a continued focus on fraud and also on registration violations, and that those will occur across the gamut of the entities that you mentioned, so NFTs, token issuances, exchanges and intermediaries. We are looking at all of the places where investors and markets are likely to encounter risk and where those risks are going to be greater as a result of a failure to comply with existing regulations and to provide the sorts of robust disclosures that other issuers and other market participants consistently provide to U.S. investors.
And I know that in talks we've had before that the cases that, as you've looked at them in the past and going forward, attempt to show that the importance of registration in this space and disclosure that goes with the registration. What would you say to we'll say the skeptics out there, okay, that would suggest that framework is not appropriate to crypto? And in particular, that, for example, a disclosure regime for token issuers, may not be as effective as you might see, for example, in a disclosure regime for operating company, more traditional operating company securities, for example. Or that even if people wanted to register, the SEC hasn't registered, approved enough entities for there to be robust activity in those markets. So it's sort of a two-parter, disclosure and registration in that sense.
Sure, absolutely. So on the disclosure piece, I think that it is possible that there are material risks posed by token issuances, by intermediaries, by others that are nuanced or in some ways different than the risks that are posed by other issuers. And I think that our registration program is flexible enough and robust enough to accommodate those differences, and that people can come in and work with our Division of Corporation Finance, our Division of Trading and Markets, our Division of Investment Management, our FinHub, and talk about, maybe I've got more of a round peg and you've got more of a square hole. How do I make sure that I am providing investors the types of information that you expect me to provide, that the securities regulations require me to provide, consistent with the subtle differences in the way my business operates, or even the significant differences? I think there is room to have those discussions and to still comply and register, and that we have been sending that message to industry for quite some time. The chair has been out front and very vocal on this point, that he expects people to come and register, and we expect to be able to work with people who are expressing an interest in doing so.
Okay, so you've bought me then, okay? I'm going to come in, I'm going to register, okay? Where will my token trade?
So without identifying any individual entity or platform, there are some that there are brokers that have registered. There are, I believe, ATSs that have registered. There are other kind of commercial entities that are exploring registration. I mean, fundamentally, we are there to be responsive to industry and to help them get registered, but we cannot create the commercial environment for them to do so. They have to see that there is a financial benefit available, and I personally, and again, calling back to my disclaimer, these are very much my personal views, it seems like there is an opportunity there for someone who come in to be compliant, to be registered, and to offer users a degree of risk protection and confidence in the operations of that entity because they are complying with U.S. laws, that would allow a broader user adoption than may be available when many consumers, in light of recent events, have some skepticism about getting involved in the crypto industry.
And I know it's a little bit unfair to put you in the position of coming up with the commercial solutions for this. I know that we've discussed your role is enforcement, and you're enforcing the role of the regulations that you see are out there. And so with that, there's been a lot. Okay, I mean, again, if you had to try to pick the cases that are out there, for us to do so, everyone would have their own special, and each one of us will talk about some of them. But what are the ones that you in particular, coming from the SEC enforcement side, would want to point our attention to in the past year?
So there are a number, and I claim zero credit for any of them. As you indicated, I'm new on the job as of October 1, so this is highlighting the great work of the staff who I have the privilege to supervise, but I claim no credit for their successes here. So some notable cases include the Kardashian settlement we reached for violations relating to touting. The BlockFi case, where we applied the Reeves analysis in addition to Howey, and also brought a misrepresentation claim and reached a settlement that they also reached with the states. The hydrogen moonwalkers case, which I think did not get enough attention, but I think is really important, and that involved a market maker manipulating the value of a token and creating the false appearance of organic demand and liquidity to allow an issuer to kind of sell out into the market. And the Wahi insider trading case regarding Coinbase. I think all four of those are really important in separate ways, and I know my colleagues here plan to speak about them, so I don't want to steal their thunder, but I think all of them are representative of the breadth of the work we are doing, the scope of the challenges we face, and like the vulnerabilities that investors can face in surprising and unexpected ways at times because they aren't getting the full, robust disclosures they might get in other types of investments.
And without stepping too much on, and I guess I know that Michael and James are going to talk a little bit about some of those cases too, but why is it so important to the SEC that those cases, what are the, and again, without spending too much time, but for each of those cases you mentioned, you identified 4 out of dozens of cases you brought this past year. Why do those cases stand out, and for what proposition?
So for the Kim Kardashian case, I think that is important because it is hopefully an indicator to investors that they need to be considering the source of investment advice they may be taking and whether that investment advice is based on that person's true beliefs or if there's a conflict of interest created by being compensated to provide the advice and not providing adequate disclosure about the source of that compensation or the amount of it. I think for the BlockFi case, I think it has to do with the quality of disclosures being made and the protections that can come along with being registered and the vulnerabilities that exist when they are not complying with both their state and federal obligations. I think for the hydrogen moonwalkers case, in traditional markets, I think a lot of investors will look to a variety of signals to indicate where they want to invest their money and how they price for risk. And those can include sales, expenses, headcount, executives, all sorts of things. I think often in crypto, people may rely primarily on trading volume and price movement. And to the extent that those signals can be spoofed because people can trade amongst themselves behind the opaque walls of centralized exchanges or through pseudonymous identities, that makes the primary signals investors are relying on much less reliable and makes it harder to know where risk lies. And in Coinbase, I think it's very important to show that the same sorts of violations can occur even when you're involving a crypto token as opposed to a more traditional investment, an insider trading case, and the same sorts of remedies and tools will allow us to bring enforcement actions as appropriate in those instances.
Thanks. And so, it'd be hard to have this panel without acknowledging the collapse of FTX last week, and without getting into any investigations that may or may not be ongoing with respect to specific entities. Obviously, the collapse of such a major market participant has to have some impact upon the SEC, or maybe not. How do you see the collapse of such a major market participant affecting the SEC's approach in this space?
So providing the obligatory no comment regarding non-public investigations, the existence thereof or not, taking one step back and just talking about consequences. I mean, first, feel very badly for those people who lost significant funds as a result of that. I think that those losses can impact people's financial well-being and their personal well-being. And trying to protect those people and the integrity of markets is why I do the job I do. And so when events like that happen, it pains me and it motivates me to continue this work. As far as the agency overall, I think the chair has been out front and very consistent in his message that we want people to come in and register and honor their disclosure obligations so that investors can decide what risks they're willing to take and they have the information necessary to be able to price for that risk. And that there is a runway for people to come in, get registered, particularly intermediaries and exchanges to come in and get registered and provide investors the kind of confidence and security that our other national securities exchanges offer U.S. investors. But I think that likely that runway is growing shorter and enforcement is ready to stand up and continue its work and move forward. And if people are not going to come in, entities aren't going to come in and honor their compliance obligations, then that's what our enforcement division is there to help assist with and to bring enforcement actions as appropriate.
Yeah, thanks, David. And so let's turn over to the defense side. And I mean, obviously, again, we've talked about the panoply of cases. David's identified some. What stood out to you as you look back over the last year, James, in terms of the activity in this space?
So going back a year and probably a little bit more than a year, we really started to focus on what messages is the SEC sending through its enforcement actions, and I'd say also the CFTC in one instance that I'll talk about. What are we learning about, look, we know it's not 2018-19 where you could look at ICOs and say, okay, well, we know that's a problem. That's pretty easy. Things are a little more complicated now. The market the digital asset space has gotten a little more complicated. Try to position what they're doing as, this is a token that's a utility, and which I think has sort of lost its meaning over time. And so, we've moved away from the idea that this looks just like a security. We're at least not calling it something that sounds like an IPO. But that hasn't really changed the fact that there's real concern about how those tokens operate. So when I'm advising clients, when we're advising clients, we really have to drill down much further. And so the actions help. Understanding that there's, the SEC has taken action against DeFi platforms, against lending. I'll mention the CFTC and its action against Uki as sort of saying something about DAOs that's very interesting. All of this says something to us about how we need to really closely analyze all this. And frankly, it gives us some confirmation, but also raises other questions. And I'll talk about some of these cases in that context. So, when we think about, for example, the Coinbase action, the SEC versus Wahi, what's interesting there is that you have a situation where someone traded on information about when these tokens are going to be listed, giving this information to his brother and to a friend so that they could profit. And you say, oh, that sounds like a traditional insider trading case, except these tokens haven't been declared to be securities. At least there's been no court ruling that that's the case. And so, wait a second, let's think about that. What does that mean? And so, in that instance, I'm studying the complaint and looking at the 9 tokens that were, alleged by the SEC to be securities, because that's telling me something about the SEC thinking. Now, it's sort of high level, and when you really dig into these things, you look at all the facts and circumstances, and you have to go, deeper than maybe presented there. But at least it's giving me something to think about when I'm hearing about various projects and saying, well, this looks like this or that or the other thing, and I think that's a problem. Each of these actions ends up sending a message in some way that as we try to navigate this space and navigate for clients who are trying to, frankly, comply with the law, figure out whether or not they do have something that's a security. Frankly, if they're going that route, they need to go that route. If not, then let's talk about what you need to be thinking about and whether or not your project really satisfies the prongs. The other thing, another action of interest, of course, is the BlockFi case. And what I think was sort of interesting there is both the fact that you bring into it the Reeves test and the family resemblance test and thinking about loans, really highlighting the fact that there are different types of securities to consider. I also think it's incredibly important to say, by the way, you don't necessarily just have to think about SEC enforcement or federal level enforcement. You need to think about the states, because the states have their own rules and regulations, and I think they had to pay approximately like $50 million or so in penalties to the states. And the other reason I think about BlockFi is, frankly, because of your more recent actions. And look, I can't help but be influenced by the news of the past week. And I know they had paused withdrawals because of their involvement with FTX US. And that just sent a message about, wait a second. And I think you can find many instances of this. So many of these companies are interconnected in some way that when you think about corporate governance and oversight, it really starts to make you think about what can happen to the extent that this interconnectedness creates problems on top of the ones that we're already thinking about. So these are some of the things that we're thinking about. We're really trying to analyze these situations more closely. We're taking in what we learned from FinHub and conversations about client projects, and really closely analyzing each action as it comes out and thinking about where does this put us now? How does this step forward? And of course, waiting someday for legislation. It's going to be a while, and we'll see what happens there. The one other thing I'll just mention quickly in terms of Kim Kardashian, I say thank you, Kim. You managed to make more public through your following the fact that anti-touting is a real thing. Apparently, DJ Khaled and T.I. and Steven Seagal and Floyd Mayweather several times haven't managed to send this message. But you can send the message that others were unsuccessful sending. Now we all have some understanding of what that means, hopefully, and can figure this out and make appropriate disclosures.
Great, thanks. So, Michael, and what about you? Any cases stand out to you this past year?
Sure, and I think it starts with what David, you were saying about the different kinds of cases you're doing now, and I think you spoke about both the fraud cases and the registration cases, and I think that's been the trend. When I was back with the SEC, early crypto cases were crypto cases, but they were really fraud cases. Whatever I was selling you, if I was taking your money and going to buy a mansion for myself, it was sexy because we called it crypto, but it was really a fraud case. And the evolution, I think, is to your point, a lot of the cases we're talking about start with, do you have to register? What are the requirements? And is this going to ultimately be deemed a security? And there's really two questions there, right? There's is it a security? And respectfully, it's a slightly different question. Is the SEC going to treat it as a security? And to James's point, when you're advising people early on, you look at these complaints for clues. Those clues give you great clues as to what the SEC thinks. And so our advice has to be very often, part of your analysis has to be whether you're going to have to win in court before you prove otherwise. And of course, the other question is, what's the court going to ultimately find? And so the two cases I'd focus on in that regard, because they spill over in so many different ways, are the recently decided library case and the maybe soon to be decided Ripple case. They're related in the sense that we're still asking what's a security. I wouldn't overplay one being relevant to the other. I think the judge took a very fact-specific approach in library, and I think, frankly, the judge will take a fact-specific case in Ripple, because I think that's what the SEC is asking everybody to do and saying, we're going to look at your specific facts. Other than maybe Bitcoin, there aren't a lot of specific factual circumstances that have yet publicly passed the SEC test. But I think each of these cases does provide us with clues of maybe where we're going to land on more clarity of where the public can say, here are some indicia of what ultimately will pass muster. In library, you saw, and this helps us advise clients on the front end, the judge took a very close look at what the company was saying early on in describing its own investment. And I think that's going to happen in any case. That's not going to be the end, but you're going to have trouble walking back comments about something looking like an investment contract if you later want to prove it's not an investment contract. In library, we also had the notice argument that the public wasn't on notice of really what was a security. We have a similar argument in Ripple. I think we have different facts and certainly a different factual record there. And maybe if the judge decides on that ground, it may have I need to find a better word for ripple effect there, but some spillover effect. But I don't think a judge coming out in Ripple and deciding one way or the other is going to signal to everybody the fight is over. I don't imagine you, David, are going to say, never mind, we're not going after any tokens anymore. And I don't think the other side is, the defense bar is going to take the opposite position. But I do think that how library was decided and how Ripple will be decided will continue to educate us on how we can approach the SEC on what factors, what specific facts get us a little bit closer or further away from what's an investment contract. And it gets back to something you were saying, James, which is the interrelatedness of all of this. We can talk about 20 cases here that don't specifically focus, at least the primary focus isn't on whether something is a security. But it's going to matter to the case ultimately. Whether you're trading in a security in an insider trading case does matter. You have to call the question of whether it's a security. It may be the reason why the criminal case only kind of sort of calls that question. Whether you want to get applied to be on an exchange, whether you're even in these touting cases. I think the overlap you mentioned, David, with these market manipulation cases is fascinating, and it has the potential for great growth. It probably is going to keep your doubled staff pretty busy over the next few years, but it's still going to come back to that same question. If you don't have a security, you don't have as busy a job. And if you do have a security, you have a whole lot of cases you can bring. So I'd start and end with library and Ripple, not just because of what those specific decisions have or will tell us, but because the underlying question that's going to affect just about everything on your docket, I would imagine.
In responding to that, I would say that is the initial question we always face within the SEC is jurisdictional. We do not have authority over every type of investment that could be offered in the US. We have authority over securities. And so the first thing we have to try and determine is this within our kind of regulatory ambit? Is it a security? And go from there. So yeah, I completely agree with that assessment, and that's going to continue to be something that we devote a lot of time to, and it is a facts and circumstances-based analysis. And so we go through and try and provide as much detail when we reach the conclusion that there was a security and that it failed to register, and we bring an enforcement action, because we know that the defense bar and others, developers, the industry itself, is paying close attention.
Yeah, and that's helpful. It also has real impact on some of our clients who are not in the business of issuing tokens or are not even in the business of registering. But they know that if they even invest, there may be what some clients may call a crypto tax. The SEC is going to call them just for information or just for a quick interview. Not with any allegation or even suggestion of wrongdoing, but it's a real expense for getting into the business. So the more clarity they have of what the SEC is looking at, the better for the whole industry.
Yeah, and I think you had mentioned that you were seeing an impact on there with the clients in terms of the impact that the crypto investigations were having, not simply on crypto issuers or market participants, but just investors and the like. What are you seeing there in terms of the burden on clients in this space?
Well, it's significant, particularly where it isn't clear when the SEC is going to call. If you invest in a more traditional S&P 500 stock, you kind of know what the SEC has traditionally looked at and where they may go. Sometimes you have investors who may be very sophisticated, but in many cases maybe just new to the industry, new to a growing industry, and they get a call from the SEC and they turn to counsel and say, why am I being asked to spend thousands and thousands of dollars? I'm not an issuer. I'm not a platform. I didn't realize the SEC even had authority over me. And what I'm hearing on this blog or the other is they may not even have authority over me. And so we get to that threshold of jurisdiction. And so I think, you started out by not taking credit. You're going to get a lot of blame from the industry, so I would start taking credit for the successes. I think your staff has been, in many cases that we've dealt with them, helpful in trying to scope the difference between the giant investigation that's targeted at a potential wrongdoer and trying to be accommodating, at least in certain instances, where you're just looking for information. I mean, I don't know if you can speak to any of the experiences you've had trying to right-size the scope for people you know really aren't at the wrong end of something, but you need information from.
Happy to speak briefly to that. So our jurisdiction to bring enforcement actions is significantly more narrow than our jurisdiction to seek information that might lead to an enforcement action. We have the authority, if we have a formal order in place, to issue a subpoena to gather the information we need so that we can get the facts and circumstances to determine the scope of our jurisdiction, whether a violation has occurred and whether it's within our jurisdiction. And so we may be reaching out to people who are not the potential violators to gather that information. And this is something the staff has already been doing, but certainly something I made a point of mentioning in my early conversations with the team I now as I mentioned, have the privilege to lead, is that we have a three-part mission at the SEC. We protect investors, we ensure fair and efficient markets, but we also facilitate capital formation. And that third prong is not always the primary thing that we think about when it comes to enforcement, but it is an obligation as part of the job we all do. And part of that means, being mindful of the burden that is placed on people when we seek information from them, particularly those who are not suspected of possible violations.
Thanks. Well, in this space, and there's a lot of qualitative factors that we look at here, and a lot of talk around the factors in the Howey test and the like, facts and circumstances. So happily, we have Simona here to bring some sort of quantitative analysis and rigor to this process. And I know that Cornerstone's been very active in this space. Well, first of all, starting with the trends, what are you seeing, quantitatively as you look at the trends in the crypto space?
Yes, that's correct. So I've been analyzing the SEC enforcement activity since the very first enforcement action taken in 2013 against the shavers. And as you may know, Cornerstone releases an annual report summarizing the trends in this space. And maybe in the material you have also the 2021 report, and soon we're going to release the 2022. But I wanted to preview some of the trends that we have been seeing in these first 10 or so months of 2022. Just to have an understanding of where the Gensler administration is heading to. So first, three trends in particular. First, the SEC enforcement activity has increased in these first months relative to 2021. So as of Friday, November 11, there's been 23 enforcement action in this space versus 20 for the full calendar year in 2021. Not that we are keeping tally about it, but so more enforcement actions, and also approximately 30% are brought through administrative proceedings, while the remaining 70% is litigated in court. One trend that continues relative to last year is that we have seen more enforcement actions against individuals. The second trend that I want to highlight is the increase in interagency cooperation. So in several enforcement cases, we have seen that the SEC has been assisted by US authorities and agencies. So for example, US attorneys' offices, IRS, the FBI, state regulators, but also assisted by international authorities. And this may be a byproduct of the fact that the cases, well, there is an increasing number of authority regulators that are involved in this space, but also a byproduct of the increasing complexities of some cases that often transcend the national borders. The third trend that I wanted to highlight relates to allegations. So in terms of allegation, well, one trend that has been noted is that continues from last year is that there's more scrutiny on crypto lending and digital asset exchanges, DeFi. And last year was BitConnect, PolyoNext, Blockchain Credit Partners, this year BlockFi. But the trend that I want to highlight is the continued focus on ICOs. And that's pretty steady over time. And in particular, the interesting aspect of some of the recent ICO cases is that they included market manipulation allegations. And so hydrogen is one that's been mentioned with the allegation of spoofing or layering, but also maybe one case that has received less attention is the one against Stephen Chung. So in sum, more enforcement cases, more interagency cooperation, and continued focus on ICOs.
And where has Cornerstone been? Where are economic analysts been in these cases? What are the cases that are ripe for that sort of analysis?
Yeah, so definitely market manipulation is one. So generally speaking, before we provide some examples, economic analysis that we have performed in this space, generally speaking, the economic analysis is based on facts and circumstances and clearly varies according to the specific question. But on the market manipulation space, the issues that we have seen are well-known issues now applied in the crypto space, but the issue of spoofing, layering, wash trading, pump and dump schemes. So these are well-known, and also the technique of the economic analysis around them. And so, for example, we've seen cases of fake volume and there are economic analysis that we have performed looking at the volume patterns, the prime patterns, and the volume patterns, and compare these patterns across the exchanges. And there's some literature suggesting that when there is a legitimate volume, you expect that the hourly volume follow a certain pattern and across the day, but also consistently across different exchanges in the long run. So in a way that markets are connected. Well, where there is a fake volume, you will see more idiosyncrasies, some spikes, and where the market is now, there's not this share market fashion. So these are type of analysis that we do, but also looking at spreads, looking at the size of the trade, and so forth. Other examples beside market manipulation is really the analysis and forensic analysis of transaction data in the blockchain. And as you can imagine, this type of analysis involve a huge amount of data, like in the order of billions of trade. And so we have experience, and this is relevant not only for damages, in the context of damages, but also applications, for example, in the ICO space, so to identify the genesis block in the allocation distribution of the token and transaction. But also in FTs that clearly are unique ownership of this typically intellectual property on the blockchain. And so we follow the trade there. Well, then I think we needed to talk about analysis also in the context of ICOs. When the question is the token a security? Well, and in the age of Coie and Reeves, we've done some analysis, of course, on that, looking at the correlation of the price movements between the token and the security, the token and the commodity, the token and the fiat currencies, and also try to identify what are the drivers of really value for the token, and how the price of the token moves and varies if there are company-specific information, so in a way to highlight whether there is efforts of others. So these are just a few.
No, it's great. So I know we're going to get a couple of questions here in just a second, but before I do, I wanted to throw out one question to any panelists that are brave enough to answer it, and that is, where do you see crypto enforcement and regulation, in the coming years? And I note that 4 years ago, I answered a similar question on this panel. I think it's incredible that we've been at it more than 4 years with crypto as an issue. And I was incredibly wrong, because I assumed that we would have regulation very soon, because otherwise the SEC would have to go after everyone who issued a security in order to have credibility in this space. So maybe I'll take half credit for that, but because there's obviously been a follow-up on that. But where do you, anyone willing to answer, predict where they see things flowing out in the next few years?
Sure, why not? So look, I do suspect that we know that there are investigations of various NFT launches, and we'll see some cases coming out, I'm sure, at some point, that will be, frankly, helpful in the sense of, I think that people sort of approach NFTs as, well, they're non-fungible tokens, so we don't have any issues, right? And then people said, well, if you fractionalize, maybe then you have an issue. But the thing is, there's even more than that to talk about. So that I'm sure that we'll start to see something coming out along those lines. I think we'll continue to see interesting actions involving DeFi, where people thought, well, it's code, so there's nothing to go after. It's like, well, somebody developed the code, so let's think again. And frankly, I am curious to see what happens with DAOs that are involved in this space, because again, there was this I think, false notion that, well, it's a DAO, it's decentralized, and it's not an issue. And I don't know, some people have the notion that you have like a founder and somebody that creates something one day, and the next day it's magically decentralized. And let's face it, that just doesn't happen. And what I mentioned Coie earlier because it was interesting there is I think they throw out the proposition that you can look at each of the voting members as participants in what is essentially a general partnership, which is a truly frightening proposition. I don't know how, it'll take a while before we get there, but I suspect at some point we'll see that. And then one day, legislation, but I'm not sure when that day will happen.
Michael?
And predicting crypto and predicting Congress are not things I should intelligently put on the record, but I will try. I do think, and we alluded to it a little bit earlier, is I think in the space of market manipulation, the area is rife right now for creative schemes. And I think we're all just starting to understand some of the interaction between some of our traditional spoofing and other devices and how they can be kind of supercharged in the crypto space. I was going to turn to regulation, but I do see there's a question, so
Can we take a question or two?
Sure.
Thanks. I have a question for David. We've heard a rumor that there may be the first ever separate trial unit for a specialized unit, your unit. Is there any truth to that rumor? Or if it's softer than that, that it's maybe just some special relationship with the larger enforcement trial unit? Could you describe what that is? And separately, David, could you give us some understanding as to the reason for that and whether we can expect to see more litigation in the cyber crypto space, and if so, what nature and what's motivating that? Thanks.
Sure, I'll try and address the multi-part question the best I can. So I think we have been out front about the fact that we have created a dedicated trial unit within the crypto asset and cyber unit, and it is the first time that we have had that formulation within the Division of Enforcement. And I think there are efficiencies based reasons for doing so, that there are some technical explanations and technical details that need to be provided to the court and to juries when we're bringing cases that involve an emerging and evolving underlying technology. And so having trial attorneys who have repeated repetitions and deep exposure into those technologies and those markets so that they are more fluent and we're not reinventing the wheel each time we decide to bring a litigation makes a lot of sense. Does that indicate that we are going to continue to be active in enforcement and in litigation in the context of crypto? I think that's a fair conclusion to draw. I don't think we'd given anybody the impression we were walking away from this area, and that would not have been the right conclusion to draw. So we are going to continue to. I don't think it's an indication that we are going to be bringing significantly more cases, although, the extent there continue to be significant numbers of violations, we're going to continue to be very active. And many of these cases do end up in court. And so to the extent that is the path that the parties decide they have to take, then our litigators will be there for us.
All right, well, thank you all for the great panel. Very much appreciate all the insight, and have a great day.